Okay, hey everybody, this is Tim Blankenship with Divorce 661 again. Today we are going over how to prepare your response form and how to serve it. Does need to be served, and in what order does that get done? Stay tuned to the end because I want to tell you why you may not want to file your response. There's several reasons, but I'm going to go over that with you at the end. So if you're watching this on the replay and you don't want to watch how to complete this form, skip to the end. You don't want to miss that. All right, so let me share my screen and get right into the completion of this form here. And okay, here we go. The response. Okay, so when you need to respond is if you've been served, the summons says you have 30 days to file a response, and this is the form they're talking about. So let's get into it. You're going to mark the box. This is a response and request for. People miss this all the time. It will cause issues with your case, so make sure you're marking and request for. And you're going to mark dissolution of marriage. That's going to be the case 99% of the time, at least that in my experience over the last 10 years. That's been my experience. So if not, you're going to mark whatever may apply. Legal separation of marriage, domestic partnership, whatever the case might be, that's what you're going to mark. But whatever you do not mark two options. Pick one. All right, legal relationship. You're going to mark we are married, unless these other issues apply because you went with a different selection here. Residency requirements. Is it you or your spouse that has been a resident for the state and the county for the last 3 months? It doesn't have to be both of you, but if it is both, that's okay too. Statistical facts. And if you'll notice, if you have looked at the petition, this is almost or is an exact copy. It's just called a response and says respondent requests as opposed to petitioner requests. So statistical facts, date of marriage, enter that here. Date of separation, enter that here. What I talked about when I was discussing how to complete the petition is do not leave the date of separation date blank, even if you're still living together. If there's not a date in the past that makes sense, just use the day you are preparing this form as the date of separation. Don't forget to do the math and do the years and months of the length of marriage. Next section will be children. No, there are no minor children. Yes, the minor children are. And you're going to list your kids. Okay. First name, middle name, last name, date of birth, age. As I talked about in the completion of the petition form, if there is a child born before the marriage, you're going to want to locate that voluntary declaration of paternity. It's a document you would have received in the hospital at the time of birth. If you cannot find it, and many of our clients are unable to locate it, it will not stop your petition or response from being filed, but you will need a copy of it at some point because you're going to need to attach it to your judgment page. Page 2, legal grounds. Okay, respondent contends that the parties were never legally married. You're not going to do, and these are not going to work. We haven't had to do these in 10 years. I'm just telling you. We handle amicable divorces throughout California, and maybe that's why, but all you're going to mark is respondent requests divorce for irreconcilable differences. I just got off the phone with someone today. They're asking, what reason do we need to state for the divorce? And there is not a specific reason. We just say irreconcilable differences. And I know filing the response for, some people that aren't wanting to get divorced but they were served and it was a surprise, you still want to file this response. And yes, I know you may not want the divorce, but in filing the response, you still need to mark respondent request if you want this to be filed properly. If there's children, you're going to make your specific requests here. Are you asking for joint custody, joint physical, joint legal? Do you prefer there to be child visitation versus there being joint custody? And as I mentioned in the completion of the petition form, these are not mandatory, these additional documents. It does not say not mandatory. All you need to do is complete the response, but you do not have to make any specific additional attachments in there. In fact, even if you requested them, and there's a lot of additional information you can include regarding the custody, it doesn't mean you're going to get it. You can request it, but again, it just says respondent requests that the court make the following orders. Hopefully you guys are having an amicable divorce and you're going to have a settlement agreement drafted, and that is what will supersede everything in the response. We just had, in fact, the client had hired us for an Orange County case, and I completed the petition and sent them out for signatures. And they said, "Hey, it doesn't say anything about the terms of our agreement." Well, that doesn't happen in the petition because these are just requests. The marital settlement agreement that's drafted that gets submitted along with the judgment, that is what that is where those agreements go. And again, it does supersede the requests in the petition. So as long as you don't make a mistake on here that would cause your judgment or cause the response to be rejected and thus your judgment be rejected, everything you put into the settlement agreement through mutual agreement will supersede the requests in here. For instance, let's say that you in here say you want to request spouse support payable to yourself as the respondent, but then later you guys agree that there's not going to be any spouse support. That's fine. But going back into filling this out, you are going to make the requests and whatever those requests are at the time, whether you're asking for it, whether you want it to be terminated to one or both, or if you want it to be reserved for future determination to either one of you. And the way I explain these to our clients is that the box A is that do you knowingly want spouse support now? Yes or no? Or do you know that you will never want to pay or receive spouse support in the future ever? Or I don't want it now. I may want it later. That's what box C is. This is the maybe box. And then you can mark these boxes here. Separate property. And then on page 2, there will be community property. And just like I mentioned on the petition, because again, this is just a duplication of the petition essentially, is we're not advising if you're watching this, we are not advising that you put property on the petition or response. We do not put property on the separate property on the petition response. And as I mentioned, we simply will say, and again, we're talking about these are amicable clients going through an uncontested divorce or a default with a written agreement, not a true default case. All you have to say here is something like to be determined or to be amended or something like that. You don't have to list the property here. Listing the property can cause you problems down the road. And again, we're not talking about true default cases where you really are forced to list the property in the petition or the response. We're not attaching property declarations for our clients. Again, not needed, not required in amicable cases where it's either an uncontested divorce or default with written agreement. Again, same with the community property. We're just saying to be amended, to be determined, something like that. Sometimes I'll get fancy and I'll say parties intend to enter into a written stipulated judgment on all issues. Again, it doesn't really matter. Just put something so it doesn't appear to have been left blank. Attorney's fees and costs. Again, for our amicable clients, we're not addressing this. Our fees are not attorney's fees. These are people going to court that eventually want to have their spouse pay their attorney's fees or something like that, or court fees, and that all is determined at a later time. If you are the respondent and you want to have your maiden name restored, you can enter that here. The other box, not something we're usually completing. There's nothing, there are specific requests that you want to include, but this is not necessary to complete, and we're not filling this out in most cases. Date, name, signature. If you have if there's minor children, I'm sorry, you also need to complete the UCC JEA, that is the FL-105. And I've already done a video on that. You can find that on our YouTube channel. Just Google how to, Divorce 661, how to complete FL-105. Even though it was prepared previously on the petition, when there's minor children, you still need to complete the 105 when you're filing and serving the response. One thing I want to say that's different about the response is, and I'll give you a contrast with the petition. When you prepare the petition, you have to first file that. It will, sorry, let me back up. I think I just cut my audio off. When you file the petition, you have to file it before you can serve it. With the response, you have to serve it before you file it. Why is that different? Because you have to have a proof of service attached to your response. So on the petition, you get that filed, you get a case number issued, and once you have that, you're going to serve that on your spouse, and then you file the proof of service. It's I don't say it's backwards, but it's different when you do the response. You have to attach a proof of service to this. So the proof of service obviously has to show it's been served at least on the same day. So you'll attach the proof of service and complete that. Again, I'm going to go over the proof of service with you and the easiest form to use on that. But you're going to complete the proof of service showing that it's been served and put in the mail by the party serving. And then you will file your response with the attached proof of service. So let me show you that form. I'm going to bring that up here. Okay. And so here's the proof of service. This is the easiest way to do it because because the response can be filed. Can be served by mail. You can just use a standard proof of service by mail. Again, this will not be served by you. You cannot be the person. You can complete the form, but you can't be the one that is the named person as the server. So very straightforward with these forms. Your address, or I should say your address, the party that is serving this paperwork, what was served, you'll just say response. And if there was, children, you can say UCJEA. By placing the envelope for collection, either one of these boxes is fine. It just depends on what you did. Name of the server, address, of person served rather, the date it was mailed, and the place of mailing. So in our case, Valencia, California. We're not worried about this because we're just talking about filing the response. So this is a very simple way to do a proof of service if you want to just have that response served and attach this proof of service to that. Now, I wanted to talk to you about, if you notice the title of this was about, do you need to, how to file this and serve the response, how to prepare it, which we just went over, and one reason not to. So we handle amicable divorce cases. I probably said that a couple of times. With our clients, we go through and have them go through a process called default with written agreement. So let me back up. A default with written agreement is the same as an uncontested divorce, except in an uncontested divorce, there are two filing fees. The definition of uncontested means the petitioner filed a petition and the respondent filed a response. That's the true definition of uncontested by the court's terminology. Default with written agreement means default because no response is being filed. The benefit to this is you don't have to pay a court fee to file a response because you're not filing it. What a lot of people don't know is they'll say, yeah, we already filed for divorce. The court fees have been paid. No, if you go to file the response, that's going to trigger that secondary court fee, and you're going to have to, pay that fee. Why do that if you're amicable? For the last 10 years of us doing this, we will put them through a default with written agreement. Again, they're amicable clients. They're reaching a full agreement on all issues. We file the petition. They pay the court fee one time. We file the default with the default judgment, and the respondent is doing nothing different except not filing the response. They're fully involved. They are signing the marital settlement agreement. They still have to do their disclosures. They're doing everything but paying the fee. So definitely a good way to go if you're amicable is not file the response. Save your guys some money. That's how we do it for our clients. If you guys are going through divorce anywhere in California, we work with all the courts. We can start from scratch with you, or like half our business comes to us. And if you started your own divorce, we can take over. We do a full takeover, finalize your paperwork for both of you, prepare everything. We have flat fees. We don't do retainers. Very simple process. Everything is done electronically most of the time with most of the courts. We can even partnered with notarize.com to have you have electronic notaries. So super simple process. Like the person I just got off the phone with, we just took a case in San Diego. He said, it sounds like it's kind of like buying a house and going through escrow and signing documents electronically. And that's really what it will feel like when you use our service. So I hope this was helpful. Feel free to go to divorce661.com. You can schedule a free consultation. If you're thinking of using our service, we can talk about what you got going on, and we'd be happy to help. Take care.